Ladies and gentlemen, welcome to the QT Faculty of Law for today's conference on intellectual property and education in the age of COVID. As is always the case, we'd like to acknowledge the traditional owners, and in keeping with the spirit of reconciliation, we acknowledge the traditional owners of the lands where QT now stands and recognise that these have always been places of teaching and learning, and we wish to pay respect to their elders, past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islander people continue to play within the QT community. And in the context of debates around intellectual property and education, there has been very significant discussion about the importance of Indigenous intellectual property. Today's event is going to look at some of the relationships and connections and intersections between intellectual property and education. It will cover many different species of intellectual property, spanning copyright law, trademark law, patent law, trade secrets, and questions of licensing. In many ways, the conference today is also going to span an array of different disciplines within education, everything from the creative industries to medicine and biotechnology and even clean technology. In addition, this event is also going to focus upon open licensing within the educational institutions. So the use of open licensing to promote open access, open innovation and open data is also a very kind of important dimension in terms of the debate and discussion over intellectual property and education. This event is also going to focus upon the role of universities and educational institutions and research organisations in responding to the coronavirus COVID-19 public health crisis. So universities and research institutions have a very particular special role to play as keystones in the knowledge infrastructure. They are generating a whole wide range of technologies that could be of use in tackling the coronavirus crisis, including vaccines, treatments and diagnostics, as well as a range of other public policy solutions. So this event, amongst other things, is going to think about ways and means in which we can encourage public transfer of some of those research and public policy solutions. Finally, this event is also going to be an Australian launch for this research handbook on intellectual property and technology transfer, edited by Professor Jacob Rooksbury from Gonzaga Law School. This collection provides a comparative analysis of how an array of different countries manage intellectual property and technology transfer from educational institutions, and also kind of includes a contribution by myself looking at intellectual property and higher education and 3D printing. So welcome everyone. I hope you enjoy today's range of presentations looking at different aspects of intellectual property and education. Thank you. Our next speaker is a Masters by Research student at QT, Samuel Lobão, and he's going to talk about copyright law in South America, digital exclusions, libraries and cultural venues, unleashing new opportunities and experiences. And this is part of some of his research, looking at intellectual property and 3D printing in the context of realising some of the United Nations Sustainable Development Goals, including the one specifically focused upon boosting education and literacy. Samuel.
Thank you, Professor. It's a great opportunity to be speaking here. It's feels good to be back to some normalcy, to some new speakings, like to some symposiums. It's been a hard time for everyone, and especially for South Americans. I would like to start with, like, since you did the introduction, with small acknowledgements. The situation due to COVID, like in South America and Latin America, it's not good at all. Uh, I sometimes I make like a joke with my wife that, like, living here in Australia with such a time difference to Brazil, it's like waking up in Walking Dead. Like, you wake up and, like, you have like this wave of news, and one of the news today was like the loss of someone that I wasn't personal friend, but I knew, Rodrigo Rodriguez. He was a prominent, like, sports journalist in Brazil, and he is one of the close to 100,000 victims that, like, COVID has done in Brazil. The second acknowledgement, it's about the importance of, like, we start to speak about the effects of COVID-19 to indigenous people, like South America and Latin America. It's harbors like many of the cultures, many of the indigenous peoples in the world, and they're pretty much being neglected in levels of, like, that we could actually speak of genocide. And the last acknowledgement is just like a consideration to the fellow students and members of the international community who are stranded all around the world due to closed barriers. So here are my thoughts and prayers to them. So I'd like to speak with, like, about copyright law in South America. First, a little bit of background on the context. Despite many of, like, common knowledge, South America was, like, and Latin Americans were really late to the party in relation to copyright law in the ways we have today. Like, we had our own agreement called the Buenos Aires Convention. It was totally different in certain aspects to the Berne Convention, which was adopted by TRIPS Convention. And one of the most significant, like, difference was that the Buenos Aires Convention, which stood, like, for over half of a decade for most of those countries, it required formalities such as deposit, registration, notice, certificates, payment of fees. So there is, like, this feeling that copyright was, from the beginning in South America, it was restricted to the elites. Like, unless you had, like, the amount necessary to go throughout all of this, you wouldn't have, like, copyright over your work. And that was based on the Buenos Aires Convention. The change to the Berne Convention, to the ways that we have today, which doesn't require registration, doesn't require, like, amount of fees and deposits and extra steps, just require, like, a creative work fixed in a material medium. It was only with the adoption of the Berne Convention. And for many of those countries, the adoption of the Berne Convention only came due to TRIPS. And TRIPS also brought, like, with the Berne Convention, the notion of copyright exceptions and limitations. So the very own notion of copyright exceptions and limitation wasn't something that was natural for South Americans. It was something that, like, came later. We pretty much imported, like, what was the current model. And the way we imported was pretty much like the way. It was a mixed bag of what the Europeans and what the Americans did. Like, of course, we have expressed limitations such as teaching, review, satire, but we also have, in certain ways, a restricted three-step test that allows the judges in Brazil, like, to have certain flexibility to analyze case by case. But not only in Brazil, but other countries following the civil law. However, there was a very interesting research done by Kenneth Curious back in 2017, where he collected, like he analyzed all the countries within Latin America and Caribbean and tried to see, okay, so what are the actual exceptions and limitations that are in place for Latin Americans, especially in the context of libraries, cultural venues, and surprisingly enough, like some that there are common sense for many of countries such as Australia, United States, Europe, were not present in Latin America. For instance, a library cannot make copies for general use. A library in many of those countries, like close to half of the countries, cannot make copies for the purpose of researches. Like this is something that, like, if we speak to fellow researchers around the world, they were going to speak. So how do you even research like in Latin America if a library cannot make copies of it? Another ones, like for instance, what we call the orphan works, like works that are no longer in the market, works that like they're not market interest on them, but they are own libraries that should be accessed to the people. Those cannot be copied, not even for preservation. So they're like a lot of like there's a excruciating lack of exceptions and limitations in place to many of those Latin American countries. And he followed his research with something very interesting. Not only there's this lack of exceptions and limitations, but they are getting even worse as long as like we come to the digital world, because after digitizing of some work, many of the exceptions and limitations that could apply no longer apply because they're in another medium, they're in another place, they're in the digital world. So like there's an extra barrier. One of the most interesting of those is actually it's very funny because uh, it it's common for like publishers to have digital protection measures like lockdowns in order to protect their like book, their digital, like the movie, from being copied. Uh, Although libraries may have access to the work and copy, if they could be legally binded by a contract to not break the digital locks. So technically, like there's a contractual lock for something that was like supposed to be an exception and limitation. But why does this happen? This is what like people most of the time doesn't try to answer. Why like there's this particular environment that happens specifically in Latin America. I keep like every time that I speak about like intellectual property in Latin America, I speak about IP and enemy. Enemy, it's a concept where like you have the rules, but the rules doesn't always work. The rules are there, they're in paper, but like the population doesn't follow the rules. The government's not every time enforces the rules. And like in respect to IP, I think like we don't have the IP culture in Latin America yet. Both from a utilitarian like perspective, we don't understand what are the benefits from the IP system and what are like the detriments of the IP system. Without understanding this, like it's really hard for us to craft like specific exceptions and limitations to our cases. IP in Latin America continues to be seen as a burden instead of like a catalyst for innovation or economic growth. And these are like shown every time on the indexes by the number of patents applied, the number of like new works published by Latin American authors. And this is also a reflex, a reflection that IP was top-down forced into like developing countries. Most of what we have now, like the models that we have now, are pretty much repetition and copying from like international treaties, and they are forced by international treaties. There's not like many of like there's not much inner movement to change the situation. The second reason for that, like the second reason why it's so hard to speak about exceptions limitations in Brazil, like in other countries of Latin America, is legal. Like it's a legal reason. It's like the civil law. Comparatively to like the common law, the civil law leaves much less space for you to discuss the nature of the law, for you to discuss what's the law. For instance, here are like some examples that are expressly, like under the Brazilian copyright law, there are expressly as exceptions and limitations to copyright. One of them is you can have short excerpts for private use. But there's no definition what's like as a short excerpt. So this causes like a, a, such amount of like difficulties for judges and courts to like try to feel for legislation, feel for like what should supposed to be like the legislator's job. This is like what we call how we interpret, like in the case of the civil law. We have the legislation. First, the judges need to go to the legal positivism, like what the law says, and there's like just after that, there's a little space for them to try to interpret what's like what the law tries to say. And the way this translates in terms of copyright law can be seen like in many of the concerns that Latin American countries say when there's like a new treaty in regards to intellectual property. This, for instance, is this response of Brazil in the consultation of the Marrakesh Treaty. Brazil pointed that it's very concerned about the risks that the difficulty in defining universally what is working accessible format, difficulty in defining what is reasonable access conditions. The clause would create insecurity. Though all those circumstances, I know that they also happen like on common law, but they are very aggravated in civil law. And what are the implications? What are like the implications for such a convoluted like state of like copyright law and exceptions and limitations in Latin America? For instance, recently in 2018, we have like a disaster in Brazil, which was the just completely destroy of the Brazilian National Museum. We lost like pretty much like the entire collection or most of like the collection. And there were attempts like for independent attempts to recover some of this digital collection through pictures, digital files, digital archives, 3D printing like of some of the statues that were lost. Wikipedia was very strong trying to collect some of the pictures like made by visitors in order to try to recollect some of what was lost. The problem was, due to the lack of the copyright exceptions and limitations, especially in the digital environment, there were actually cases, legal issues related to the right owners of like the collection. Many of those issues were also related to cultural heritage of the the collection they're exposed, not only like Brazilian cultural heritage, but also international, like in foreign cultural heritage. Copyright was pretty much discussed in terms of like, okay, so what are you guys trying to do is copying, digitally copying a work from like an artist. Usually like those artists are like have passed away, but like the states were very adamant in this respect to try to keep away like from this digital copying. And there were also a uh, very sensitive appeal to the reason to the question of moral rights, copyright moral rights, because many of these states which still held like the rights, they didn't want to have their work recollected in acrylic, in terms of 3D printing, in acrylic, in other materials. They wanted to keep it as the original author tried to. And this kind of like led to some interesting implications as well. For instance, one of the scans, uh, some of the scans actually like that were made from the digital collection and were posted online, the about the statues, about like other works, they were licensed by the person who created the digital files, which creates like a kind of a conundrum. Is this a type of copy fraud? Because uh, is the digitization of the work enough to, in terms of CAD file for another purpose, transformative enough to draw away like the original rights? These are questions that are surging, and it's interesting. They're appearing in a country that like doesn't have the tradition to discuss these topics. And in relation to COVID, for instance, we it's a nice follow up to Matthew's presentation. Since we don't have like the exceptions and limitations, we don't even have them. Uh, what is going on like right now is borderline illegal, to not say illegal. Like there are many universities, libraries, and cultural venues that are engaging in the COVID effort, but they are simply, I would say, knowingly ignoring the rules in order to try to cooperate with their COVID effort. For instance, many of the universities, many of the hospitals in Brazil are still linked to universities. So they are taking as so. They're taking as the same government structure. And most of them still hold the original user manuals from the equipments that need to be repaired right now. Like there are so much use, and they're bounded to copy and like share them online because we don't have these exceptions or limitations. The same applies to like CAD file for 3D printing. Like the lack of this resource, like this possibility, limits us so much. So, in order to conclude, what needs to be changed? First of all, I need to the bare bones. We need to change the culture. We need to understand as Latin Americans what's the importance of IP, what are the benefits, what are the shortcomings, in order for us to craft our own exceptions and limitations. We cannot be importing exceptions and limitations. We cannot be like using opportunities so you can use them benefit in a positive way. but we cannot rely only when there's discussion of like a Marrakesh Treaty in order to create a new exception. We need to have our own rules. We need to have our own voice. We need to understand our own policies. This is only going to happen if we start to have an IP culture like in Latin America. Thank you.